Professor Dunn, welcome to Constituting America's Constitutional Chats. We're going to ask if you'll give a few minutes on our topic today, which is that of judicial review, and then we'll open it up for questions.
Thank you so much, Kathy. It's a real honor to be with you. I've seen the work that Constituting America has done for many years, and it's a great service to the country. So it is a privilege to be with you and to talk about judicial review, and in particular, Marbury versus Madison. So before I get into the details of Marbury versus Madison, I want to make two maybe arresting claims at the beginning to hopefully grab people's attention. But it's difficult for me to think of a case that's more misunderstood than Marbury versus Madison and more overrated than Marbury versus Madison. And I'll say a little bit about that second part so that people don't get too alarmed at this point. Notice what I didn't say. By saying overrated, I did not say unimportant. It is an important decision. But because it is misunderstood, people often think that it did something which it in fact did not do. And so to properly understand the case, I think we have to look at two things. We have to look at the political context surrounding it, and then look at the decision and the reasoning itself from Chief Justice Marshall. So to properly understand the case, you have to start with the election of 1800. You could go back before that, but really the election of 1800. And I'm guessing that your audience is familiar with the election of 1800. There's a major event in U.S. and world history, first peaceful transfer of power by election in the modern era. But of course, the Federalist Party lost power, and the Democratic Republican Party took power. You had Thomas Jefferson become president, of course, after it goes to the House of Representatives, but you also had the Democratic Republicans take over Congress. This was deeply alarming to the Federalist Party. They really feared for the future of America, and they wanted to do something, and they also feared for the future of their own party. So they wanted to do something to try to shore up some of their influence in our political system. So they created many new judicial positions in the lame duck Congress in the intervening months between the election and when the new Congress and president came into office. And these were known as midnight judges by the Democratic Republicans. So because the judiciary was the lone institution that still was composed largely of Federalists, they were able to put more Federalists on it. And then this would allow them to maintain control and influence to some degree in our national politics. Well, the Democratic Republicans were not happy about this, but also some of the commissions, including some for magistrate positions, justice of the peace positions, were not delivered by none other than John Marshall. In the kind of tumult in between the transition from one administration to a next, Marshall was not able to deliver the commissions before he assumed his new position as Chief Justice. Of course, the new Jefferson administration comes in, they find the undelivered commissions. They felt that they were illegitimate to begin with, so they decided to not deliver the commissions. Well, the Federalist Party decided to create a test case to really go after the Jefferson administration. And the person who led the test case was none other than William Marbury. He was a wealthy businessman from the District of Columbia in Maryland originally. He did not need the position, but he sued asking for the Supreme Court to order a writ of mandamus. He went directly to the court. This is crucial. Went directly to the court and said, make the Jefferson administration, James Madison in particular, deliver my commission, requesting this writ of mandamus. In those intervening years between 1801 and when the case was decided, 1803, there were some other important things that happened. The Congress, in fact, essentially canceled the Supreme Court's term for 1802, or a couple of terms that meant that the court didn't meet for 14 to 16 months. They also rescinded many of these judicial positions on their own with a new Judiciary Act of 1802. So the case finally gets to the Supreme Court in 1803. When you think about the political context, you can understand that John Marshall and the Federalist Supreme Court was in a very difficult position. They had two really bad options. First, they could order the Jefferson administration to give William Marbury his commission, but they would just be ignored by the Jefferson administration. In fact, when they heard oral argument, the Jefferson administration and Madison didn't even show up to defend their side, indicating an almost contempt for the Supreme Court. So they knew if they ordered them to deliver the commission, they would just be ignored. That could fatally weaken the court. They did think that an independent, strong judiciary was essential for the survival of America, so that was a bad option. The other option was to simply capitulate to the Jefferson administration, but that would also be interpreted as weakness. and would also then could potentially be a fatal blow to the power of this really nascent institution, the Supreme Court, and the federal judiciary as a whole. So John Marshall had two really bad options. He was on the horns of a dilemma. So what did he do? He decided to go between the horns of the dilemma. So what he did is that he said that yes, William Marbury was entitled to his commission. Yes, that a writ of mandamus could be the appropriate remedy. But on a third important question, he said it was not appropriate for the Supreme Court to order it. And what Marshall said was that the Supreme Court could not order the commission because Marbury had come to the Supreme Court improperly. Remember, he went directly to the Supreme Court. If a case goes directly to the Supreme Court, that means the court has what's known as original jurisdiction. Jurisdiction is just the authority of a court to hear a case. Authority of a court to hear a case. Appellate jurisdiction is the authority of a court to hear a case on appeal. Original jurisdiction is the authority of a court to hear it in the first instance. What Marshall said is that William Marbury had come to the court through Section 13 of the Judiciary Act of 1789. And what he argued was that Section 13 of the Judiciary Act of 1789 improperly increased the court's original jurisdiction, unconstitutionally increased it. And so his argument then was that even though Marbury was entitled to the commission, even though there was an appropriate legal remedy, they could not order it because this law that he came to the court under was unconstitutional, thereby exercising a power of judicial review. Now, we have to be clear on what Marshall actually claimed. In the opinion, Marbury versus Madison, he did not say that the Supreme Court was the supreme interpreter of the Constitution, that no other institutions could interpret the Constitution, that the Supreme Court would be some kind of majestic tribunal casting judgment on all acts of the legislature. That is not what he said. Instead, he made a very basic claim, and one which was understood that the court had always had. He did not invent the power of judicial review. It was instead understood as a natural feature of separation of powers. That is, that the court, in the proper exercise of its judicial power, cannot be obligated to give effect to laws that it regards as unconstitutional within its own institution. That's what it means. That's all that John Marshall claimed. In fact, remember, the Jefferson administration and James Madison had not even bothered to defend their side. What would have happened to the Supreme Court if John Marshall had come out and said, hey, Democratic Republicans, guess what? The Supreme Court, this unelected, life-tenured body of judges, is in fact the supreme interpreter of the Constitution. That would have risked a fatal backlash against the Supreme Court. It is not something that certainly I don't think Marshall would have wanted to do that anyway, even if he regarded it as appropriate, but it was politically impossible. So Marbury versus Madison really was an exercise of a much more basic and well understood power, but one that now people associate with something like judicial supremacy. And that's not what Marshall claimed. Instead, judicial supremacy is something that evolved over time, and it was much later before the court finally claimed this power of judicial supremacy, and that today is still controversial.
Well, thank you. That was a great summary of Marbury versus Madison. And I know that we've got a lot of questions. Janine, do you want us to go to you first?
Yes, hi. Okay, thank you. It's Janine Turner here, recuperating from oral surgery, everybody. That's why I'm not on camera today. Okay, I'm confused.
Yeah,
I'm going to ask questions like a fifth grader, I guess. Are you smarter than a fifth grader? Which is, I guess, where I'm trying to see if I'm smarter than a fifth grader. But it's always good for the young kids on our show to be able to understand. I read this book, Marbury versus Madison. Everybody out there thinks that John Marshall, through this judgment, and you're showing us another window to this, which is great, or the reality of it, which I appreciate, that he, by that decision, increased the power of the court in some way that did have something to do with the Constitution. And what I remember about this is it made Jefferson mad. Jefferson was very upset with this decision because he felt that he had John Marshall had just empowered the court in ways that it shouldn't have been empowered. So I think what I just heard you saying is that it's maybe he didn't say it quite as emphatically or in such an all or nothing sort of way, but there was a kernel in that decision. There were like 3 or 4 points to the decision, right? And the fourth point
Yes.
was, okay, yeah, you can't cut. The one of them was you cannot bring this Marbury. You can't bring this to this court. It had to go to lower courts first, and you came straight to the Supreme Court. So that's we hear about that type of thing a lot. It's just right, not in the right jurisdiction. But what there was a fourth point there, was there not? Just so I can understand, I'm not questioning you what you're saying at all. I'm
Yeah.
trying to understand where he did. There was something in
Yeah.
it, because I read this book about 20 years ago that gave more power to the court to interpret the Constitution, and Jefferson was very upset about it. So you want to tell us about that a little bit?
Well, I think what happened is afterwards, people started seeing the court exercise more power. The Democratic Republicans were always very angry with the Marshall Court, particularly because they would actually nominate justices to the Supreme Court, and then they would kind of fall under the sway of John Marshall. And so then that contributed to the dissatisfaction with the Marshall Court. Joseph Story, for instance, was a Democratic Republican who was nominated to the court, and then basically became one of John Marshall's biggest supporters on the court. I think Jefferson was more upset because he recognized that there was a kernel within the way the Constitution is structured that the Supreme Court could exercise a kind of final judgment, because there's no one above them to immediately correct their errors. And in fact, that was a debate over the ratification of the Constitution. That was one of the chief complaints about the Anti-Federalists, was that they thought that the Supreme Court could be licensed to engage in a kind of policy freelancing under the guise of interpretation, because there was no direct check on the court, even though the Constitution did not give it this ultimate power. So it is difficult to figure out exactly what Jefferson was angry about with Marshall, because there are many things that he disliked about with John Marshall, who was his cousin after all. So he was very upset about how John Marshall handled the treason trial of Aaron Burr. They became very upset with him with the case of McCulloch versus Maryland. But they also did kind of recognize that the Marshall Court was taking on many controversial issues. And they were taking on issues that people thought, well, no one's actually going to be able to write a decision that most of us would regard as getting it right. And the Marshall Court kept doing that, which then they created a pattern of people accepting the judgments of the court. And so really, I think it's more appropriate to say that this kind of judicial supremacy kind of evolved over time. And part of it was just simply because of the quality of the Marshall Court's opinions on many controversial may
I ask? Sorry to step in, but I only have 5 more minutes.
Oh, sure.
But did this case not establish a principle of judicial review?
It was already there. That principle was already there. Everyone
and giving
understood
the court the power to declare laws were unconstitutional.
Right. Yes. So you can read Federalist 78, for instance. Alexander Hamilton talks about this, but their understanding of judicial review was more limited than I think most of what we can today think of as judicial review, which is supremacy. And in fact, you could say the court exercised judicial review in a previous case, Hilton versus United States, where they actually reviewed the constitutionality of a tax that was passed by Congress. They did not say that it was unconstitutional, but judicial review is really the power to review the constitutionality of a law. And they did that in a previous
bizarre,
case.
Isn't it, that everybody in the world, even if you Google it, I mean, everything says that this case established. Okay, so if it didn't establish judicial review, and it had been established earlier, this is all very fascinating. What kind of power? Give us an example of the kind of power Jefferson did want the court to have that was switching and changing under John Marshall. So, and the Democratic Republicans were all upset that it was having too much power. But I'm not, and beyond the sway of the other judges. In other words, let's just take John Marshall out of it. Okay, Now,
Right,
supposedly, the
right.
court is this. He did something that triggered everybody to believe that the court was going to have more power than than
Mm.
than Jefferson wanted it to have. So, can you talk about
Yeah.
what? Give me some real like fifth grader examples, please, of what the court then was doing that the Democratic Republics thought was too much. It was a power that they did not want them to have.
Oh, sure. Well, partly they just disagreed with how the Marshall Court, in some cases, interpreted the Constitution. So I mentioned that case, McCulloch versus Maryland, and that was whether or not the state of Maryland could tax the national bank, and the Supreme Court struck that down as violating the supremacy clause of the Constitution.
So I
Yeah.
have to ask a question while my brain is sort of understanding what you're saying.
Yeah.
So I have to jump in. So they did not want the Supreme Court to declare if the law was constitutional or not
No,
constitutional.
they thought that the appropriate position is that they thought the Supreme Court did have this power within its own institution, but it wouldn't necessarily be binding on everyone else immediately. They were known, and I think this was the most common position among the founding generation and in the early republic, is that they adhered to something called departmentalism, and that was simply a natural feature of separation of powers, which is that each institution must, as a function of right and duty under the Constitution, have the authority to interpret and apply the Constitution, and that means that they cannot be forced to do something that they regard as violating the Constitution by another branch of government. We actually have letters from Thomas Jefferson saying this, that is his position. It's this departmentalist position.
Okay,
Now, he
let me
did
stop you right
confess.
there.
Yeah.
One sec, because I'm sorry, I really don't want to interrupt. I'm just trying to understand, and
Yeah.
I could, like once you say a couple of sentences, I have to
Yeah.
digest it. You know what I mean? Okay,
Sure.
so they thought that they had the right, the Democrat Republicans, Jefferson and Madison, to
Mhm.
interpret the Constitution, but they didn't want it to take effect so strongly or quickly. Then how did they want it to take effect?
Well, it would apply in that particular case.
Well, then if it's applying in
the
that particular
traditional,
case, then why would, I'm a little confused on that
because then
particular point.
in future cases raising a similar conflict, the court would be expected to apply the same reasoning to it. However, what they thought, and this is crucial, Abraham Lincoln was quite clear on this. If you just simply say when the Supreme Court speaks, that's it, then you're bound by obvious mistakes. And there's nothing that you can do about them. You just have to hope that enough justices
Okay, well,
die at the right time.
what did they want the recourse to be? And this is, I have 1 minute left, and this
Yeah.
is an important point. I agree with you that today
Yeah.
everybody thinks that
Yep.
that the Supreme Court's the be all, the end all, the final decision, and should the Supreme Court really have that kind of power? What did our founders believe? And Abraham Lincoln, let's put them all together, right? That if the Supreme Court makes a decision, if they did not believe that that was the final and just decision, the final decision, what was the next recourse in their minds? I think I know what that is, but what was the next recourse? If the court doesn't have that kind of power, but they say something's unconstitutional, what in their minds was the next step to correct that or combat
So
that?
on some things, there could be other issues where you simply could ignore the court's reasoning and apply your own understanding of the Constitution. Abraham Lincoln did this many times as president, where he simply, Dred Scott said that free blacks could not be citizens, and Lincoln treated them as citizens, so they could just act in ways that indicated that they did not accept that reasoning for other issues. Then they would also try to work to change the public understanding of the Constitution to arrive at a proper understanding of it and interpretation of it. They simply did not think, though, that you could just that whatever the Supreme Court said would then be finally binding on everyone, because in the end, that would make the decisions of the Supreme Court more important than the Constitution itself. And that cannot be the case.
There has to be a recourse. It seems to me like the best recourse would be to take it back to the legislative branch, potentially.
Jefferson's position was, if you really want someone to ultimately be in charge, he preferred the legislative branch, but he did argue for this what's known as departmentalism, where each branch must interpret the Constitution.
Yeah. Okay. All right. Well, thank you so much. I'm going to pass. This is fascinating. Appreciate it.
So Tova, we're going to go to you next.
Oh, okay, amazing. Well, thank you so much for being on. Oh, pardon me. So I wanted to ask, you make a really interesting argument about the interpretation of something, so foundational to how we view constitutional law. And I was curious whether you view your argument as more historical, so sort of tracing um, how the argument has historically been shaped and has been interpreted differently from what the founding fathers, or some of them at least, intended, or are you making a sort of normative argument about how things should be moving forward? So are you proposing any changes to how the Supreme Court's decisions are viewed, or are you more just sort of analyzing the historical trajectory?
I think it's both, because I think there are consequences for this misunderstanding of the court's power. But it is historical, and this is not. This argument is certainly not unique to me. There are many books on this from a range of constitutional scholars, from a wide range of ideological and political perspectives, where they just kind of recognize that it's very difficult to reconcile this understanding of judicial supremacy with the text of the Constitution. And then people have gone back to look at what did they actually say, what did they actually think, and it's very difficult to find people arguing for judicial supremacy. You start to see it maybe developing some a more robust version of judicial supremacy in the 1830s, but I think it really comes to its full flourishing in the 1850s with Stephen Douglas and the Lincoln-Douglas debates. He's the one who gives a full-throated defense of judicial supremacy. His position is, well, the Supreme Court has spoken, that's it, we just simply have to accept it. And Lincoln was not willing to do that, because he thought that the Supreme Court's decision was flagrantly wrong for many reasons. Lincoln said that no decision is binding until it's fully settled, and if you look at his requirements for fully settled, almost no Supreme Court decision is fully settled. So I think the normative part comes in when we now think that this constitutional interpretation is just the province of the Supreme Court. And so we outsource constitutional interpretation of the Supreme Court. And even our elected officials in Congress and presidents say that they're going to outsource a constitutional interpretation of the Supreme Court. I actually think that's a violation of their oath of office. If you take an oath to uphold the Constitution, that means that you are obligated to try to figure out to the best of your ability what it means. You can't just simply say, well, I can turn this over to the Supreme Court. There have been presidents who have actually signed legislation where they've said, I think parts of this are unconstitutional, but we'll leave it to the courts to sort it out. Members of Congress have voted for legislation where they've given speeches on the floor of the House and the Senate and said that. I think that's a terrible thing. I also think it affects ordinary American citizens, because if ordinary American citizens think that, well, this is just the province of the Supreme Court, then they themselves don't have a duty to read and try to understand the Constitution. And I actually think that ultimately it is the power of the people. We ultimately control, and there's this amendment process. It's a very difficult process, but ultimately it is the people who have this authority. And so by thinking that it's, well, that's just something for the justices on the Supreme Court to do, it allows us to escape our duty as citizens.
And so what would be the alternative if there's not if the principle of judicial supremacy is, as you claim, illegitimate, and Congress people are sort of improperly outsourcing interpretation of the Constitution to the Supreme Court? What would be the alternative system?
Yeah, it's this departmentalism, or sometimes known as coordinate review or concurrent review. And you could say it's an invitation to constitutional dialogue. Jefferson, he does talk about this. He says he recognizes that if there's no one branch that's given sole authority over interpretation, you can have conflicts. He says that could result in inconvenience. But he says the prudence of public functionaries or public officials and public opinion will resolve conflicts. And I actually think that you can see many areas which we don't regard as constitutional in nature, but are extremely challenging and difficult, and maybe rise to as being important as a constitutional issue, that are still resolved through this process of dialogue and deliberation.
And what does that process look like in practice? Um, like especially since we have the Constitution, and we all agree that we are obligated to uphold it, but different people, maybe depending on political party or personal inclination, might have different sort of interpretations of what is constitutional and what's not. And so I guess I'm trying to understand, without having a body like the Supreme Court who make judgments on the constitutional acceptability of a certain policy, what's to stop certain politicians or elected officials from claiming something is constitutional, or truly believing it's constitutional, but having other good faith people who might vehemently believe the opposite, sort of without judicial supremacy? Could you help me understand how those sorts of disputes would be resolved?
Yeah, so there would be negotiation and dialogue among the branches of government, in the same way that we resolve many really significant policy disputes. I think, after all, about the debt limit. That could be as consequential as any constitutional question that you can imagine. But yet, that's all we always seem to manage to work through that. The branches of Congress and the president manage to come to some kind of accommodation. And I do think what you would see is more public deliberation about the meaning of the Constitution. That's what would happen, is that people would actually start pointing more to the text of the Constitution itself and try to make more grounded constitutional arguments. But again, I do recognize that there are some who think that this would be highly inconvenient, even more than Jefferson allowed. And I also recognize that this is the text that's in the textbooks. This is what you'll find in a lot of elementary school, junior high, high school, and college textbooks. But again, if you read the decision itself, that claim is simply not there. Instead, judicial supremacy arose through other means, and people have read into it things that simply Marshall never could have actually said, given his political circumstances.
Right. Yeah, that makes sense. I'm just trying to understand how that would work in practice. Like, how would those deliberations actually occur? Like, it seems to me that there's sort of a foundational difference between a question of constitutionality, which, at least under our current interpretation, isn't something that is necessarily negotiated. Like, something is constitutional or isn't, and people can agree or disagree on the reasoning. Versus policy within the bounds of the Constitution, there's super wide leeway on what that can be, as long as you get the requisite amount of votes. So how would that system of deliberation work with something like constitutionality?
Well, I think you can maybe even see some examples of this where Congress has voted for things where it's regarded, where it's you've had members of Congress say, I regard this as unconstitutional, but I'm going to vote for it anyway. But there was still a public deliberation about it. So, for instance, with campaign finance laws, there have been many cases where there's actually been a real serious debate among some members of Congress about, does this actually infringe upon core First Amendment rights? And there's a dialogue back and forth among members of the House, members of the Senate, and then between the Senate and the House, and then Congress and the president, and then they try to work through it. But then there are, of course, going to be conflicts that would arise, and then those can be challenged in court. And again, under judicial review, you can take cases to the Supreme Court, and the court's decision will be binding to those parties in that case. Everyone recognizes that. But then there can still be other issues that could arise that you don't have to necessarily regard as being completely controlled by them. Even Ruth Bader Ginsburg talked about this. She talked about how it would be healthier for us to have a dialogue about the meaning of the Constitution and different kinds of constitutional rights among the different branches of government, rather than having what you would call heavy-handed judicial action to try to resolve these constitutional disputes.
Great. Well, thank you for that explanation. I only have a few seconds left, so I guess I'll ask about the role of public opinion on judicial decisions. You mentioned that with regards to Marbury versus Madison. So could you talk broadly about how public opinion might already influence judicial opinions?
Well, yeah, there's that old line that the Supreme Court has followed the election returns. I think that's unfair to the Supreme Court. the Supreme Court is designed, the judiciary is designed to provide some political insulation to the justices, precisely so that they can give dispassionate justice to the parties in the case. That's the most important reason that they have this kind of political insulation. However, they are part of our society, and these changes in society are not going to just leave members of the court unaffected. However, you do hope that when they are deciding cases, that they aren't going to go straight to the opinion polls and say, how should we decide this case, or decide what this right means in this particular circumstance for this particular person, because of what the public thinks about it. I think that would be a violation of their judicial duty. But there's no doubt, of course, that they are in many ways shaped by the society that they live in and these broader changes in social attitudes.
Thank you so much. That was a great answer to with a short amount of time to answer a very broad question. So I appreciate it, and I will now pass on. Thank you so much.
All right.
Hello, Jewel Gilbert here, and a great show so far. I found it so interesting. So I have a really big type of a big picture question, because when we go back in time and we study something like this Marshall opinion, and with the Marbury case, and we hear about judicial supremacy, it is somewhat ingrained in our heads because of textbooks, commonplace talk, everything else that you've mentioned. Now, when we go back to the text of the decision and we see that there's clearly another way of interpreting it in light of the founders' positions that we have from their other writing, because I do think that matters. I think the Federalist Papers matter. I think it matters to see that they already were concerned about the Supreme Court as they designed the government, that these were real concerns that they had. In light of all of that, we can see this other way of interpreting the decision that does not include judicial supremacy. And we can also see judicial review as being possible to be have been established before the Marbury case. So all that being said, I wonder if part of this comes down to our modern understanding of language at odds with the founders' commitment in this type of Enlightenment idea to rationality, that the founders had an idea that words meant what words meant, and that although we're going to disagree, that we can come to the truth through the Socratic method, through debate, and that words mean what they mean. So if we write this, we will disagree, but we can come to the truth. And maybe today we have a more of a postmodern hangover or idea that we need interpretation, that things are, that ideas are not their ideas, but they are their interpretation. And maybe we are somewhat plagued with that assumption. We don't even realize it.
Yeah, so I actually think you could see some Supreme Court cases or some statements by Supreme Court justices over the last 50 to 70 years where they've come close to saying something like that. That the Bill of Rights, for instance, and the Constitution are full of majestic generalities, indicating that they are glittering generalities. So there's no real content to them, and they're just kind of waiting for Supreme Court justices to pour meaning into them. There's no kind of inherent content there. Although I think in the end, the text ends up being a kind of sticky instrument, because now, there's always going to be some malleability and flexibility with this. Even James Madison talked about this in the Federalist Papers, about how language, there's always some imprecision with it. But it turns out that we can know a lot about what the meaning of the words are, and they can exercise significant restraint on the decisions of public officials and of justices. When it really comes down to it, most people adopt something like the position that words have meaning, and you can't just make them mean whatever you want them to mean. When lives are on the line, that's how people behave, right? If the CIA gets a terrorist laptop and they find a document on it, they aren't going to just say, oh, well, these words are just glittering generalities. No, they're going to try and really dig into them and figure out what the people who authored them meant by them. And we do that with most texts. I do it when my wife gives me a grocery list. I'm not allowed, if cereal is on the list, I don't get to just sit there and say, oh, well, geez, this should be Fruit Loops and Captain Crunch. It's her understanding of what cereal should be, right? So I think that when the stakes actually are really high, people try to treat text with sufficient care and respect, and don't treat them as just a kind of mere plaything that they can manipulate at will.
Yeah, and when I'm sitting in my college classes, which I'm done now, but in the past, it's almost like we had the luxury of just being all theory, and you have the luxury of taking ideas to where they're outside of the practical, really. But our founders fought a revolution, and there was a lot of really many of them literally fought. So they lived in the practical world while having these amazing lofty ideas. I'm reminded of our Amazing Winners trip, where we have a Jefferson actor who plays Thomas Jefferson, and he does a wonderful job. And I always remember every time. They had these amazing ideas, and yet, he was debating with Alexander Hamilton, who was literally on the front lines at times of the Revolutionary War. That's an amazing thought. So they didn't always have the luxury of that we have, to be only theoretical and not see what the point that you're making, which is, we may say that, but we don't live that way when a paramedic shows up, or we don't live that way when it comes down to it. And I would agree as well. But what I wonder is if the American people, as voters, as citizens, then also need to have have faith in the truth again, in a way, like believe again as a whole that there is that we can come to truth for reason, that it's not going to be perfect, but that we can come to truth for reason. I don't know if I think that would really be something that in this discussion we opened up. We were, at a town hall, and we had everybody's opinions before us. We had every political spectrum. That one of the first issues would be, do we agree together that we could come to the truth of an issue? And with this, I see, the concerns on both sides about the Supreme Court's power as being real and legitimate. And what you're saying with compartmentalism, I believe you put it, or departmentalism, one of the two.
Departmentalism, yep.
Departmentalism is a cure to that, and not seeing judicial supremacy as something that, seeing it more the way you said that Lincoln described it, as a solution to that. But I don't know if the majority, especially hearing it just in a moment, like not having a long time of thought, I don't know if the voters or the citizens would be able to have faith in that process, unless we first got down to everybody saying, hey, guys, we do believe in truth. We do believe words have meaning. We believe in the logos, and we can come to an understanding of what we write down. What's your opinion on that?
So I think that the process of actually deliberating over the meaning of words can force people to start to recognize that. Again, there's only the words themselves impose some boundaries. There's going to be some room within them. But the more you are forced to actually grapple with the text, the more it forces you to recognize that it can't just mean anything at all. They are there for a reason. Those words are there for a reason. And after all, if they weren't there for a reason, you wouldn't why have a constitution at all? Yeah, that would be we could do without it. So I think that the actual process of grappling with the public meaning of the text can force people to recognize that they have to have to realize that words have meaning, and it's our job to come to our best approximation of the truth about what they mean.
Yeah, I definitely agree. And it seems like it comes back to education then. Again, that does come back to somewhat, like reading the Constitution and the things that are our goal here.
That would help.
Yeah, before we were asked to do, before I joined the podcast again, I maybe thought about the Constitution between having won the contest and being back on the chats. But so I had, I've read pieces of it, but then being back on the chats and every week having a deep dive discussion about the Constitution and never running out of content even a little bit kind of makes me realize just the depth of the richness of what it takes when you understand this document, that it really does have to do with everything in our life as American citizens, and that study of it really doesn't end. And it's an interesting thing to continue to study his life, and it's part of our power and our responsibility. But again, then the people have to choose to do that. So I guess in my closing question is, so we've talked about judicial supremacy mostly, we talked about judicial the judicial supremacy versus judicial review. Is there anything else that you have not brought out of this in your opening statement about the Marbury the Marbury case, which we kind of missed in our questions, or do you think that we've talked about the crux of it?
No, I will just say I realize that some people might find this deeply unsettling to hear someone say that, oh, what I thought this case said. And I will tell you, that was my first response when I heard about departmentalism. And then I actually read some articles that provide a more careful reading of Marbury versus Madison. I actually remember I wrote a paper for a grad school class for a wonderful professor, became a dear mentor of mine, Martha Durfick, where I actually argued for judicial supremacy. And I realized after I turned it in that I didn't actually believe any of it, that I didn't think that it actually didn't make sense, that I couldn't reconcile supremacy with the Constitution itself. And it just over time, it kind of you start to recognize this. And I think, again, this is a common position among many constitutional scholars. And also among many political actors. Now, it's difficult for them to say this publicly, but we have had recent presidents come very close to basically saying they don't agree with judicial supremacy. President Obama, in his State of the Union address, where he discussed Citizens United. I think President George W. Bush on some of the national security cases where this court ruled against him, came close to Bill Clinton. President Clinton did it, came very close when the Supreme Court struck down the line item veto. And then there's a whole litany of other past presidents and political figures who have expressed similar concerns about the idea that we simply need to, once the court has spoken, that's really forecloses deliberation about the meaning of the Constitution.
Thank you. We're going to get to some more questions from the audience and any other panelists, but thanks for answering all my questions.
Well, thank you,
Sure.
Dr. Dunn and Jewel and Janine and Tova. And before we go to any audience questions, we're going to give a quick shout out to teachers and students watching today. Patricia Thompson is watching with students from Dogwood Academy. Michelle Weissman is watching with students from Trinity High School. And we also have a great niece of James Madison, whose name is Kay Morrison, descended from James' brother William, a Revolutionary War general who had 11 children, while James had none. But let's see, Kay Morrison's brother is named James Madison Morrison. So welcome to all those listeners. If you're a teacher watching with students today and we didn't give you a shout out, be sure and put your name in the Q&A, and we will before we get to the end of the program. We also want to thank our listeners from Las Vegas's KKVV 1060 AM on the radio dial. KKVV airs Constituting America's Constitutional Chats on Thursdays at 6 p.m. Pacific. So Janine, I'm going to go back to you real quick before we go to audience questions.
Oh, goody, goody, goody. Okay, I'm contemplating about this. This is really a philosophical and, of course, a constitutional conversation. It's most intriguing. I did Google a little bit, and it's saying exactly. It was interesting because it came back with sort of a nuanced answer. I'm going to read this, and then I'm going to talk about something. And then I'll finish my question. Marshall wrote, quote, "It is emphatically the province and duty of the judicial department to say what the law is," end quote. Now, I don't know where he wrote that, giving the Supreme Court the final authority on constitutional questions. But then it goes down here and it says significance. The power known as judicial review did not have explicit textual support in the Constitution, but was established by Marshall through his interpretation, which is exactly what we've been talking about, exactly what you've been saying. But here's my philosophical and constitutional question for you. My question is, we are a nation of laws, and we are a republic where we vote for our elected officials to represent us, and then through that constitutional process, through presidents who are elected, and through the Senate who gets to approve justices, the Constitution kind of takes that further down the road, and through our elected officials, justices are appointed to the Supreme Court, and we are a nation of laws, and we need to have a structure, and we need to have respect for the laws. And the flip side of that is, if we don't, is anarchy or democracy. And in democracy, of course, it would be like a poll where we want just all the American people to kind of tell us what they think. And we're not a democracy. We're a republic where we sort of hire people through our vote to go do these things with more in-depth thought than we are capable of doing in our everyday lives, trying to just survive our everyday lives. So since we are a republic, and since we don't want anarchy, and we are a nation of rule and law, if we just suddenly have a bunch of presidents that go, you know what, I'm not going to go by that, I'm not going to go by this, or if people say, well, the judge said that, but I'm not going to believe that, and I'm not going to do that, I think there has to be a 1, 2, 3 sense of, if the Supreme Court does not have the final say, which, by the way, I don't think it does, what are the next logical, lawful steps to undertake to combat that decision? Because if we just willy-nilly say that people could go, you know what, I don't want to abide by that law, or the president says, no, I don't think so. I think that leads to a lot of dysfunction in the country. So I think this discussion is philosophical, but we need to sort of answer it with a very staid, specific kind of course of action.
So a few things. First, that quote that you read from Marshall, there's a word missing there that is crucial, and that word is only. He does not say that it is only the province and duty of the court to say what the law is. What he was expressing there was that in the ordinary course of its business, the court has to do what everyone had always understood that courts had to do, and that is, if you have two conflicting laws, you have to say, all right, which one is the higher one and which one is the lower one, and you have to give greater authority to the higher one. So what he's really arguing for there is constitutional supremacy, and this is what the court has to do. But he was not saying that it was only the duty of the court. And also, I think there is a misunderstanding to think that the rule of law means the rule of judges. That is not the case. The rule of law is created through a constitutional system. And as you described it in ours, this very elaborate Republican set of institutions that filter public opinion, put it through this kind of gauntlet of deliberation through the states, through Congress, the president, and also the Supreme Court. It is all part of it. It is all part of it. And that's the difficult thing, that there is no simple, that's what's so attractive about judicial supremacy, is that you can just, so that's it. We just do what the court says. There's an easy kind of response to that is, what do you do when the court gets it wrong? What do you do when the court gets it wrong? And frankly, the amendment process is not an effective check on the court. It just isn't. And so how do you actually address? And so that's where you end up with this kind of murkier, maybe less clear, but I think more constitutionally honest and correct system of public deliberation that forces all of us to reflect on what the Constitution
but then
means.
Again, we don't want a bunch of judges making their decisions based off polls or
no, but that's not what this would say.
Just so our listeners, our students understand, the Supreme Court justices are supposed to rule based off what the Constitution says, not by a poll or not by public opinion. Right. So I need to toss it back to questions, but I think that this is a philosophical conversation in the respect that we haven't figured it out. As you said, it's kind of murky, but it's such a dangerous sort of conversation if we don't make it really clear that we have to abide by the rule of law. We are a republic, and if the court gets it wrong, well then, okay, the legislative branch can go back and say, wait, we're going to do a new law. We're going to reassess this, and then we'll send it back to the Supreme Court. Or I just don't feel very settled with people just being
I
able
understand.
to say,
Trust me, I went through exactly what you're going through now. But if you
I
believe in
think that
if you believe in
those that are
judicial
listening.
supremacy, if you believe in judicial supremacy, Congress can't do anything.
Okay, I'm not saying I
except try to
do
pass
believe,
an amendment.
but I'm not.
Yeah.
But I'm not saying I. And
Yeah.
I got to go. But I'm not saying I
Yeah.
do believe in judicial supremacy. I've already
Yeah.
said I don't. But
Right.
what we've all been asking on
Yeah.
this
Yeah.
this
Yeah.
Zoom, this podcast,
Mhm.
what are the next logical steps that are lawful? What are the next
Right.
steps within our government to then say, well, instead of just the president going, no, I don't think so, or some public poll, we
Oh.
have to be able to think, okay,
Mhm.
what's the next step? And that's what I think it's a little
Right.
anarchy and a little dangerous with this conversation if we
Right.
don't really understand what the next steps are.
So I think the next step is that you it's not that the president can just do whatever the president wants. That's what the whole system of separation of powers and checks and balances is designed to do. There's still going to be these checks there. So if the president does something, that can be litigated. Congress can respond. Congress can also impeach and remove the ultimate the ultimate check. But there's not. It's going to vary from issue to issue, and there's just going to be a lot of deliberation that would have to that would have to occur, and so it's not.
Okay.
Yeah,
I got to run
yeah,
because I got to make sure people have time
yeah,
for questions.
sure,
But thank you. I think
yeah,
I'm going to kind of settle on the fact that
yeah,
the people can voice their opinion, and the representatives can take it back to Congress, and they can write a law, or
oh,
start it from the drawing board again. Is one of the great ways to do this. Okay. Thank you.
mhm,
Okay,
yeah.
tossing it back.
Well, thank you. And Lewis White says, first of all, best conversation of all the great guests y'all have had on. So, Dr. Dunn, you've got.
All right. I have one person who's not so deeply alarmed that. Yeah.
But Lewis makes a point that I think is important. He says, comment not necessarily a question, but you may ask his opinion. As the supreme law of the land is the Constitution, per Article 6, Section 2, it is supreme over all three branches and the states. The Supreme Court was supreme in rulings over lower courts. Would you agree with that? And then I guess the other point too is just that the supreme power is the Constitution.
Yeah. So you will have to go back to that fundamental fact about our system, which the Constitution is this is the supreme law. And if you have any approach towards the Constitution that could elevate something above the Constitution, you've made a wrong turn. And that's ultimately, I think, what judicial supremacy does. Yes, the Supreme Court's decisions must be binding on lower courts. That doesn't mean the court is going to get it right. However, it is a hierarchical institution, and if you are a lower court judge and you think the court has gotten it wrong, I think you really you maybe have a couple of options, but the most obvious one is that if you think you're being obligated to enforce something that you think is fundamentally in violation of the Constitution, you should probably resign. If you think if you are being forced to do that, there might be occasions where you could recuse or something like that. But that's the only way a judicial system can function. The orders of the higher court must control the decisions of the lower courts.
Well, thank you. And we are right at the top of the hour. Gary Porter says, fascinating topic. Wish we could get this discussion in front of all Americans. And then one other, just maybe very quickly, Jordan Ulrey says, what suggestions that we, both citizens and state legislative members, can you suggest for state legislatures fighting overreach and concurrently the federal swamp fighting back as well?
Well, it is. Yeah, I don't know that there are some, but I think there's actually interest among both red and blue states right now to think about how, look, the system of federalism is designed for there to be flexibility and diversity throughout our country. And states do have the authority to talk back. They do have the authority to talk back, and they can, through negotiation and dialogue with the federal government, make some headway with that. And there are good examples of that in the past. So I think sometimes states just need to decide that they're going to talk back to Washington, but recognizing in the end, of course, that they're probably going to have to reach some kind of compromise. But they are states, and they do have their own constitutional basis of authority.
Well, thank you. And we thank you so much for your time and expertise today. This has been a fascinating and enlightening discussion. And we thank our audience for all your questions. And with next week being Labor Day, we are going to take a day off from Constitutional Chats and resume on September 9th. So we'll see everybody back on September 9th.